Parts of a lawful contract. Number 1. Parties competent to contract. The parties to a contract should be competent, being of the age of consent, of sound mind, not disqualified from contracting by any law to which he/she is subject. A flaw in capacity may be due to minority, lunacy, idiocy, drunkenness, or dissimilarity of kind. The parties should be of the same kind, being either legal fiction actors or natural living men or women, allowing more than two parties, but never a mixture of these kinds and their respective jurisdictions. Number 2, free and genuine consent. The consent of the parties to the agreement must be free and genuine. The consent of the parties should not be obtained by misrepresentation, fraud, undue influence, coercion, or mistake. If the consent is obtained by any of these means, then the contract is not valid or legally/lawfully enforceable. Number 3, full disclosure. When negotiating a contract, full disclosure is the step of providing all material information or telling the whole truth about any matter which may influence the decision-making of the other party or parties before they decide to enter into a contract. If either party fails to make full disclosure, the contract is null and void. Number 4, valuable consideration. The consideration is something of value possessed by the parties that is brought to the contract table. This something of value is bargained for and given in exchange for a promise or a performance. The parties must each receive a benefit and each suffer a detriment. To be enforceable, a contract must have valuable consideration. A contract is unenforceable if it has insufficient or unequal consideration without agreement. Number 5, certainty of terms. The terms and conditions of the contract must be fully disclosed and agreed upon, and must be certain and fixed. Any subsequent variation of terms must be agreed. Number 6, meeting of the minds. A meeting of the minds, consensus ad idem, occurs between the parties when they recognize each other, understand their mutual obligations, and agree. A meeting of the minds occurs between living men and women in lawful matters, common law jurisdiction, and between legal fiction actors in legal matters, admiralty maritime jurisdiction. A contract must either be either lawful or legal if one party to a contract makes a signature or as an accommodation party to a legal fiction person, while the other party makes a autograph for a living man or woman. The parties are of unequal kinds and the contract is null and void. Number 7, autographs or signatures. Lawful written contracts between living men or living women must carry the wet ink autographs of the parties, comprising living identification such as a thumbprint, but more often living standing is recognized by an unambiguous declaration with the handwritten wet ink autograph, including the prefix, quote, by, colon, unquote, and or the words, quote, all rights reserved, unquote, and quote, without prejudice, unquote, written below. Legal written contracts between legal fiction actors must carry the wet ink signatures of the parties as an accommodation from a man/woman. 8. Privity of contract. A contract exists only between the parties. No third party can obtain rights contained within a contract or buy or sell a contract without the express permission of the original parties. This is the parts of a lawful contract.